Step number 1, open the probate. What does that mean? How do you open a probate? Again, probate is a legal process. What that means is that it is in front of the court. So if you reside, for example, in Spokane County, you will, after your death, and if you have a will, the person you named in the will, they're called the personal representative. They take your will, they file it with the court along with what's called a petition to open the probate. That is how the probate process is opened. That is how it is started. Now, if you are trying to do a probate on your own, you'll find that the clerk of the court is not going to give you any legal advice. You likely can find forms online, petition to open probate and an oath, etc. If you're working with an attorney, likely they are drafting all those pleadings for you. So first step is to open the probate, file the will, file the petition. Who does it? The person in charge with this responsibility is the person who's named in the will. They are called the personal representative, or they are called the executor. It's the same thing. It's the person who is responsible for opening the probate and proceeding with the probate action. If there's no will, that means that nobody has been appointed by a legal document to say you're going to be responsible for administering the estate. So then what we rely upon is, what do the statutes say? And the statutes in the state where you reside will say who has the ability to serve as the administrator of the estate. Administrator means the same thing as the personal representative. So the statute in Washington, for example, will say that the surviving spouse has the right to serve. The adult children have the right to serve. And who has the right to serve, and I don't want to get too complicated, also depends on, is it all what we call community property, or is there separate property of the decedent? So there has to, when there's no will, it gets a little bit more complicated because you have to define what kind of property did the decedent leave, community or separate. If there's no spouse or no adult children, then more distant relatives then have the right to serve as the personal representative of the estate. Keep in mind that even if you are named in the will to serve as a personal representative, you don't have to. You can choose to decline to serve. Why would you do that? You might do that because you just don't feel that you have the time or the capacity, the ability to do so. So hopefully when you were named as a personal representative, the decedent spoke with you and said, "Are you willing to serve?" And you said, "Yes, absolutely, I am." But sometimes people, they don't even know they've been named as the personal representative. And if you don't feel you have the ability to serve, you don't have to. Somebody else will step up, whoever is named next in the will, or even if nobody is named next, the court will appoint somebody to serve. What does that petition to open the probate look like? What it is it's giving a summary of the person who died. It says who they are, when they died, where they resided, who are the beneficiaries of this estate. And that means of the will and of what we call non-probate assets. So non-probate assets could be an IRA or 401k, 403b, life insurance. So it's not just who is named under the will who can be a beneficiary, but who is going to be receiving assets that don't pass under a will. So the petition will say who are those people. The petition should also say who are what we call the heirs at law. Those folks are defined under statute to be who would inherit if there is no will. Even if there is a will, you still need to identify who are the heirs at law. So let me just give you a really quick example. An heir at law of a single person will be their adult children. If one of their adult children died and they left other grandchildren, then those grandchildren are the heirs at law. And even if those folks are not receiving under the will, they are called heirs at law. And in the petition, you're going to say who they are. And in a moment, I'll be talking about the fact that you need to give people notice, those folks notice that you've been appointed as the personal representative. Another thing that's in the petition, and this is really important and very much misunderstood, is whether or not the estate is solvent. That's really important under Washington law, because if the estate is insolvent, meaning the debts exceed the assets, the debts are greater than the assets of the estate, then the court is going to be much more involved in the probate process. It is going to be what is called an intervention probate, meaning that everything that is done is going to have the court's stamp of approval. That makes the probate much more expensive if you have a lawyer helping you. If you don't have a lawyer helping you, it's going to make it much more complicated and involved because you're always going to be in front of the court. Whereas in a situation where the assets are greater than the debts, then the court isn't involved. It is what we call a non-intervention probate, meaning the court opens up the probate by signing an order, but that's all that they do. The court's not involved after that. Yes, there will be pleadings that are filed with the court, but the court isn't involved. You're managing it yourself as a personal representative. When it comes to the assets, when we at ELG Estate Planning prepare the petition, we will typically say that the assets, that it is a solvent estate, and that the assets exceed the liabilities by greater than $10,000. In other words, we don't say what the value of the estate is. We don't put any details. We just say, court, this is a solvent estate. And that's what we would put in the petition. All right, so we talked about what do we include in the petition so that the court will take a look at it and say, oh, here's the will. It's attached to this petition. Everything looks good. Nothing is causing the court to say, do we have a problem here? As the personal representative opening up the probate, you also need to sign what's called an oath. The oath basically is where you say, I'll do my job. I will, under oath, say I will do what the law requires me to do, and I am qualified to do so. There are no disqualifications to me serving. What might be a disqualification? People who are felons will be disqualified from serving as the personal representative. So that's how the probate is open. Petition is filed with the will. The oath is filed. The court takes a look at it. The court signs an order. By the way, you submitted the order that says this probate is starting and everything is good to go. Congratulations, step one is done. You have opened the probate.